Generally, a prisoner is limited to one round of habeas corpus review. However, exceptions exist. Under one exception, a prisoner may have additional habeas petitions considered if necessary to prevent a fundamental miscarriage of justice. What must a prisoner show to qualify for this exception? The United States Supreme Court addressed this question in Schlup v. Delo. Lloyd Schlup was convicted of murdering a fellow prison inmate and sentenced to death by the state of Missouri. Schlup unsuccessfully appealed the conviction in state courts. Acting as his own attorney, Schlup filed a habeas corpus petition in the federal courts that was also unsuccessful. Schlup got an attorney who filed a second habeas petition, alleging that Schlup was the victim of misidentification and was actually innocent. Schlup claimed he'd been wrongfully convicted because his trial attorney had been ineffective and the prosecution had withheld evidence during the trial that would have proved his innocence. Relying on the Supreme Court's decision in Sawyer v. Whitley, the district court refused to consider this second petition's merits unless Schlup presented clear and convincing evidence that no reasonable juror would have voted to convict him but for some constitutional error at trial. The court found that Schlup hadn't met that standard and denied the petition. A divided Eighth Circuit applied Sawyer's clear and convincing evidence standard to affirm the denial. However, several judges argued for an easier standard. The Supreme Court granted cert.